Hello and good evening. My name is Grant Smith Ellis. I am reporting live after today's major court hearing at Suffolk Superior Court between State Treasurer Deb Goldberg and former chair of the Massachusetts Cannabis Control Commission, Shannon O'Brien. O'Brien today was arguing a motion related to allegations that she has put forward across an ongoing civil case challenging her fall 2024 dismissal at the hands of Goldberg, suggesting that there was an effort by staff members and fellow commissioners at the Cannabis Control Commission to, quote, take out O'Brien with pretextual allegations of misconduct as a form of retaliation due to O'Brien uncovering herself ongoing cover-ups, allegations of cover-ups of serious abuse by high-ranking CCC staff members towards at least 4 female staff members of the agency, along with allegations of dangerous products reaching consumers by way of manipulated testing of cannabis products, and allegations internally of nepotism and other conflicts of interest that have undermined the functioning of one of Massachusetts' largest regulatory agencies that has brought in overseen $7 billion in revenue generation over the past 5 years alone since the legalization of adult use cannabis in the Commonwealth in 2016, 2017, after the legislature updated the citizen ballot petition which made adult use cannabis legal. Today's court hearing between O'Brien and Goldberg specifically was about an effort, a motion by Goldberg and the state's Cannabis Control Commission to keep secret a 1,700-page appendix that O'Brien had filed herself as an attachment to her original civil complaint against Goldberg seeking to overturn O'Brien's firing and or challenge that firing in the state's Supreme Judicial Court. Now, that lawsuit was originally kicked back down to the Suffolk Superior Court, which is where oral arguments on this motion initially were heard at the end of 2024 and then heard again today. This Little Towel reporter was the only camera in the courtroom on both occasions, and today's arguments in particular were devastating for Treasurer Goldberg. The judge overseeing the case, Judge Robert B. Gordon, had a number of extremely tough questions and called the level of public interest in the release of these documents and the case itself on steroids as a result of the Attorney General and the Cannabis Control Commission attempting to keep secret these documents, which outline, according to filings on the court record by O'Brien, these allegations and behavior by CCC staff members that were eventually used as pretextual justification by Treasurer Goldberg, alleges O'Brien, to justify that firing in the fall of 2024. In turn, the judge's incredulity, in my opinion, at the argument from Goldberg, who was represented by Assistant Attorney General John Hitt, along with the state's Cannabis Control Commission, was a reflection of the fact that, according to the judge, in his 12 years on the bench, he had never seen a government actor invoke something called the Fair Information Practices Act, FIPA, to supervene, in the judge's words, the rules of the court regarding impounded material. Now, the rules of the court in question related to impounded material provide, according to the judge, a far more narrow scope of material that can be impounded compared to the invocation of FIPA that the treasurer is arguing would justify the entire document, the entire 1,700 pages, being impounded and kept from public view. But the judge, in a moment that left Assistant Attorney General Hitt nearly speechless and unable to answer the question, pointed out that the natural conclusion of the treasurer's position would be that any court document at any time in a 30A proceeding, which this is, that makes reference to a state employee's name or any information that state employee tells to another state employee in conversation or a record of that conversation would be protected and impounded. And the Assistant Attorney General was forced to say yes, to which the judge very clearly did not agree. And as a result, it seems likely that either before the end of January or sometime in February, there will be another series of rulings in this case because the treasurer herself must file a record appendix for her part of this lawsuit as of February 12th. And O'Brien will have an opportunity to object to any proposed impoundments. But the judge in the case also will hopefully rule before February 12th as to whether these documents that O'Brien filed, the 1,700-page exhibit, will be available for public inspection, subject to some minor redactions, as opposed to the entirety of the document being kept from public view, as the Treasurer and the Cannabis Control Commission argued for. And also, interestingly, the Cannabis Control Commission lawyer who attempted to intervene as an other interested party got scolded by the judge, as the Cannabis Control Commission wanted to impound a April 2024 letter, or maybe April 2023 letter to O'Brien related to this case. But the judge, in another moment that was very out of the norm and left the judge a little bit incredulous, noted that the Cannabis Control Commission lawyer failed to attach the letter they wanted to impound to their motion to impound. So to be clear, the Cannabis Control Commission and the Treasurer are attempting to keep O'Brien's 1,700-page exhibit document from the public. And then also the Cannabis Control Commission wanted to keep some kind of letter sent from the Commission or some kind of lawyer at the Commission to O'Brien, apparently, in April of either 2023 or 2024 from the public. And the judge wouldn't even hear the Commission's motion because it was not filed properly. And the judge said, I either will take no action or I'll deny it with leave to refile because the Commission didn't do it right. So overall, horrifying day in court for the Treasurer Goldberg, and the Cannabis Control Commission. Very good day in court for Shannon O'Brien, and a very high likelihood, in my opinion, that at least some, if not a majority, if not a super majority, of these documents attached as a 1,700-page exhibit to O'Brien's ongoing civil lawsuit against Goldberg will be made public. And please take note as you're watching this hearing that the Judge Gordon, spends a lot of time during oral argument with the Assistant Attorney General, almost lecturing the Treasurer, the Attorney General, and the Assistant Attorney General, and the Cannabis Control Commission on the weighty nature of the public interest, and in this case, because of the position involved, the chair of the Cannabis Control Commission, a government agency, the fact that the Treasurer, an elected government official, is in charge of making that appointment, along with the fact that these are proceedings related to the firing of Shannon O'Brien in the context of her role as a government employee at a high level. So all of those things combined led the judge to make clear that any unilateral attempt by the Treasurer to keep some of this information public was going to be met with a fierce level of scrutiny by the court that I think it highly unlikely Goldberg's, what I would characterize as desperate arguments and attempts to invoke the Fair Information Practices Act to keep this information from the public will work. The judge made very clear that the bar is going to be incredibly high to keep information private. There may be a narrow scope of some information that can be kept from the public, but I think on the whole we're going to see this document. But I'll let you watch the hearing for yourself. You've been able to see it playing while I've been giving my overview today. My name is Grant Smith Ellis. You'll also get to see a press conference, very short press conference, with Shannon O'Brien and her lawyer Max Stern. Thank you very much for being with me, tuning in and watching this hearing. Towel was, of course, the only camera in the courtroom, so this is exclusive footage, and I will be with you for the next regularly scheduled Cannabis Control Commission hearing or the next hearing related to this matter. Let's take a look.
The CCC has also filed what I'm treating as a Me Too motion to impound the appendix that was originally filed in the Supreme Judicial Court at the time of this case's original filing. I'm treating that as essentially a duplicate motion that appends to Treasurer's motion. I don't think I need to hear from the CCC separately, with one exception. And that is there's a motion apparently addressed to a particular letter that seeks impoundment as to a letter. And I'll treat that separately, and I'll hear from you separately as to that. I don't need to hear from the CCC separately as to the broader motion to impound that went on for today. Everybody clear on that?
Yes, Your Honor. Yes, Your Honor.
Okay. With respect to the motion to impound the letter, I'm going to set that aside for the moment. I'm not going to take any action with respect to the requested impoundment of a letter that I have not seen. if the CCC or treasurer wants to seek impoundment of a letter, they need to file a procedure under Article 8 of the Uniform Rules of Impoundment Procedure and bring that matter for a cause of determination by the court. I can't do that today, not having seen the letter. Which brings us to the main motion, which is the motion to impound the appendix. I have read your papers, I've read the original briefing, I've read the supplemental briefing. You can presume thorough familiarity with everything in that briefing. It's your motion, Councilor, and I'll hear you.
Okay, thank you, Your Honor. We are asking that this appendix continue to be impounded. Just to give you context, we are here in this action on basically a certiorari review of an administrative decision. In the normal course of that proceeding, the treasurer will be filing the administrative record, which will include all the documents that were used at the administrative.
So let me add, don't lose your train of thought. Let me make sure I understand where we are in that process. If my math is right, the administrative record is due for filing at the latest February 12th?
That is correct, Your Honor. So we're in the process of assembling and getting ready to file the administrative record because a lot of this administrative record includes FIPA protected information. It will be filed portions, large portions of it, under the paragraph 2A of State Order 1-96, which provisionally impounds certain materials until a third party.
Although it sets a standard.
It does set a standard.
It sets a standard, and the standard is SJC Rule 124.
Yes.
And that, of course, is a materially different standard than the standard you were arguing under the FIPA.
Yes, Your Honor.
And is it your suggestion to the court that what you intend to do is to identify matters that you think are properly subject to impoundment under the SJC rule, or is it your intention to identify matters that you think are subject to impoundment under the FIPA?
Well, it'll be both the SJC rule and FIPA. It's still going to encounter this FIPA issue in terms of information that is being filed as part of the administrative record, that we have an obligation to protect for public disclosure under Chapter 66A, Section 2. So in any way,
Because obviously the SJC rule, the information that qualifies for protection under the SJC rule will be paper thin, correct?
yes, it's a far narrower universe of information.
But the kinds of things that are covered by that rule are quite big.
Yes, I agree.
The things that you say are covered by Chapter 66A, quite broad.
Well, and we'll have a hearing on that matter if at some point a third party wants to have access to that provision. That's how it works in the normal.
Right, although in a way on some level we're having I mean, this is a strange piece of business, right? Because the way this all arose is the case started as a petition in the nature of certiorari filed in the first instance in the SJC.
Yes, you're right. But even in that instance, an administrative record would have been filed in the single justice section of the normal course.
Well, a record of some kind, but what the plaintiff appears to have done is essentially to preempt or attempt to preempt the filing of an administrative record such as would ordinarily occur, certainly at the Superior Court level, under Standing Order 196. So all of this gets turned upside down because in the initial filing at the SJC, there was a 1,700-page appendix. When it was remanded to this court, the whole case got remanded, including the filed appendix, subject to impoundment, subject to provisional impoundment, and that's what we're here for.
Exactly right.
But in a way, we're on a timeline that this is going to ultimately collapse on itself, because we're going to have an administrative record. That administrative record is going to look an awful lot like the appendix, correct?
I can't answer that question yet, Your Honor. I think it will be vastly larger, I think, than this appendix. But the agency is still in the process of gathering up the documents and communicating those to the Attorney General's office so they can prepare the administrative report. I don't want to get the cart ahead. Subsequently, the issue of this appendix is that the appendix itself is not really serving any particular purpose. It's going to be supplanted by the actual administrative record, which will be the information that's used to review the treasurer's removal decision. And as part of that process, there's also a reference in Signal 1-96 to a redacted, appropriately redacted copy of the administrative decision under review being filed. So now backing up to our unusual issue of the appendix. The appendix is 1,733 pages.
Now, none of that, incidentally, don't lose your train of thought again, but none of that, it seems to me, stalls the progress of the case. The court is going to get a complete administrative record. We're going to get the record that is unimpounded, obviously, and unredacted. The court has to see everything that the treasurer saw.
The court is going to see the entire administrative record.
And the court is going to get everything that the treasurer saw, and obviously Shannon O'Brien's going to get everything in that record. None of this business of impoundment has anything to do with either what I see or with what the parties see.
Correct.
This is strictly an issue of what the public sees.
Correct.
And so none of this impacts the schedule of the Rule 12C briefing, correct?
It should not.
So once February 12 comes and goes, we'll have an administrative record on file. The treasurer can identify documents that are proposed for either impoundment or redaction, and that, of course, will activate a right in the plaintiff to respond to that. I think they have 20 days under the rule.
I forget exactly, Your Honor, I'm not going back. I know the provisional impoundment kicks in unless a third party seeks access to their information. It's possible that maybe
and then the time for presumably there's going to be a motion for judgment on the pleadings filed by the treasurer.
By the plaintiff. It's the plaintiff who moves for judgment on
across. But that time can be enlarged by the time it takes the court to dispose of any motion under Section 2 of 196.
Yes, and they're free to move whenever they want to move once the administrative record is filed. They can move for judgment on the pleadings as quickly as they like in up to 30 days.
It's up to 30 days.
Up to 30 days. Yes.
Right. But that time can be effectively enlarged if there is a motion pending regarding designated material for impoundment.
Yes, Your Honor. Yes. But again, plaintiff will have access to all the information, even if it's provisionally impounded. They're going to see the record and have a copy of it. Obviously, the plaintiff was privy to all the information that occurred in the proceeding before.
So the present motion is a kind of broad motion to simply continue impoundment writ large as to everything in the 1,700-page appendix. I won't claim to have gone through the entire appendix, but as near as I can tell, this all blocks out to the following subcategories of information. We would have court documents, legal documents that are not part of any administrative proceeding. So, for example, the appeals court docket, Judge Squires Lee's decision in connection with the original filing of this case. There are even references I see to case law, statutes, copies of written decisions. That's one bucket of information. None of that, I assume, will be subject to impoundment issues, correct?
Correct. Now, right now, everything is impounded, so we have to live within that. But the fact that all the information has been impounded subject to verification. You'll see in my affidavit that I attached the substance of an email that I had sent to plaintiff's counsel that breaks the universe of documents down into 3 broad categories. And I think you were just referring to what the first category of documents.
So there's a second category. What I would say the second big bucket is what I would ordinarily think of as the underlying administrative record. So that would be all of the papers that were admitted into evidence at the proceeding that we're calling the administrative proceeding.
So there's within that, there are two buckets of information. One bucket of information, the second category, is FIPA protected information that relates specifically to the plaintiff. That she provides and requested that they just provide FIPA waivers so that we can, that information can then be disclosed on the public record. So that's eight universe of information. And then the third category of information is the FIPA protected information of non-party.
I suspect that the reason you don't have that is there's a disagreement as to whether FIPA even applies to any of this.
Well,
And there's, I assume, a desire not to have the provision of a waiver be construed as an acknowledgement that FIPA has an application in this setting, which is certainly an open issue.
Right, but there's no implied waiver under FIPA. So if you look at Torres versus Attorney General on page 11, the concept of implicit waiver is not enforced as being expressed waiver.
Right, but your request, that's what your request is. You're requesting an explicit waiver, and what I suspect the reason you've now suggested that there's something undesirable about the fact that you haven't gotten that explicit waiver when it would be so easy to give you one. I suspect the reason is they don't want to have any construable inference that FIPA applies in the setting.
That may be your own, but FIPA does apply. At least the position of the treasurer is dealing with this information, protected information. She has to comply with the statute.
So let me ask you this, Counselor. You say FIPA applies. You've acknowledged in your papers there are no cases. There are no cases that apply FIPA in a Rule 38 setting or a Rule 38 type setting, in a certiorari setting. No cases like this situation, correct?
The closest case is Torres versus Attorney General, which is still a good case law. He sets forth a broad proposition. So simply the treasurer, as the holder of the personal data, has to take certain steps to comply with FIPA.
If you were correct, if your view of the world is right, wouldn't this issue arise in every 38 case? Virtually every 38 case is going to involve actions of human beings. And part of your argument is, if I understand it, that in addition to the SJC 124 category of information, anytime a human being that works for an agency's name appears on a piece of paper, that's a FIPA-protected reference. That's what I see in your argument.
I think by way of analogy, would be somewhat similar to what happens in the DCF context with the child custody proceedings, where the entire record is impounded. Of course, we review things at the trial court level and then up on the appeal level under completely impounded case file.
But in the first instance, that's the position you're going to take. That anytime there is a reference to a human being in a piece of paper, that is a FIPA-protected data.
No, Your Honor. I think our position is that if it's specific FIPA-protected information related to the individual, not all individual.
That would include the individual's name.
The individual's name or any descriptive information.
Right. Well, that's a lot of information. And to me, the thing that seems peculiar about that to me is that it would come up in every case. I can't even see that the government, I've been at this 12 years, I've never seen the government take that position in any 38 case. Not one.
Okay, Your Honor, but still...
My question is, can you identify a case where the government has taken this position?
I'm dealing specifically with this case, Your Honor.
Well, I understand. But I'm trying, you're presenting a reading of FIPA that, if you're correct, the government violates FIPA every time it litigates a 38 case without seeking impoundment of documents that reference human beings.
I don't want to argue in a circle. Maybe I'm not following what you're asking me to concede or state.
Well, I'm simply asking, I've seen no cases that apply FIPA as you are urging that it be applied in a 38 context. We're in a 38 context. So there are no cases. There is no law that does what you are suggesting this court should do. And I'm simply asking, has any agency of the Commonwealth, in any of the hundreds and hundreds of 38 matters that populate our courts, has any agency of the Commonwealth ever taken the position that you argue?
I believe it may come up in what used to be the DSS context, which would be the DCF context now, regarding to certain 51A reports and 51B reports and so forth.
51A reports are a very different kind of thing, I think, as you know, and has acutely sensitive information. It's not the government saying anytime a human being's name appears, anytime Joe said something about Jane, that we have a FIPA protected document, which is what you're saying.
Well, it can step back here. You have the treasurer as a holder under FIPA. You also have the chair of the Cannabis Control Commission as a holder under FIPA when the information is provided to her as FIPA protected. And in the context of the administrative proceeding, letters are exchanged to outline the fact that this is confidential information relating to non-party individuals, third parties, whose information is being provided to the plenary.
That's something different, counsel. So the fact that lawyers may say, I'm providing you this in confidence, I'm providing you that, that has nothing to do with my application of the law here. The parties can't simply, by agreement or fiat, say this argument is this information is legally protected. That's not how this works.
There was a requirement to balance the due process protections for the plaintiffs in her proceeding before the treasurer and providing information to her on a regular basis of the treasurer's decision. So hence, the FIPA protected information was provided to the plaintiff in the context of that proceeding. What the treasurer is doing now is simply trying to comply with FIPA. So they're in an impossible position in terms of trying to protect this FIPA protected information employees, the Control Commission, who share their personal data with the Cannabis Control Commission, with the understanding that it's confidential, it maintains private information, confidential information. Absent an order of the court, the treasurer needs to try and protect that information from further disclosure, which would be in violation of FIPA. The filing of this appendix here is simply an avenue or a vehicle for the plaintiff as a holder under FIPA to try and run the requirements of FIPA to put this information out.
You say that there were the requirements of FIPA, but I have not seen any authority that makes that so. And certainly the private discussions between the parties prior to filing the action sure will make it so.
But the treasurer is a holder under FIPA. So under the definition of holder, the treasurer is.
But the treasurer is not taking Shannon O'Brien is not taking the position, only the treasurer is, correct?
That FIPA applies.
That FIPA controls in the way that you say compels broad-scale impoundment of a 1,700-page record.
But it's not a record, Your Honor. It's an appendix. It's a document.
It's not the administrative record. It's an appendix. I agree. It's strange. It is a thing of questionable evidentiary value, given that there's going to be an administrative record filed in this case. And if there are omissions from it, plaintiff will have an opportunity under Standing Order 196 to supplement it. If there are attempts to redact material from that record, you're going to have to make a motion. And then the court will make a decision.
Yes. So I think you understand our position. The language of FIPA is clear. The statute is clear. Torres versus Attorney General sets forth the standard that has to be complied with. We don't have, there needs to be notice to the data subjects before the information is released. There's been no notice to the data subjects here relating to their information.
Again, I've never seen that done ever.
But this is an unusual case that's different than
Well, I think the things that make it unusual, this is an unusual case because of a high level of public importance, number one. It concerns the operations of an agency of our government. It concerns a former head of a commission within that agency. It concerns the performance of an elected official. I mean, this is the public interest on steroids, as near as I can see.
But Your Honor, again, proceeding of a high-ranking government official based on what are basically employment-related issues involving the confidential personnel information of uninvolved third parties that serve as the basis of the removal proceeding of the government official. So this is a very rare instance. It's not a run-of-the-mill sort of proceeding. Hence, this FIPA issue is particularly thorny and hard to pull apart and make sense of, given the very strict requirements of the language of the statute as it applies in this case.
Thank you.
Okay, thank you.
Counsel?
Thank you, Your Honor. I think you nailed it on the head when you said that the public interest in this is on steroids. It is very high. And throughout this case, Shannon O'Brien has sought the public to see the credibility of the charges alleged against her. I agree this is unusual how this appendix was attached, but at the time of filing to the civil justice, we needed to make our case and show how the actual evidence that the treasurer relied on just wasn't there. And that is why the appendix was attached. But throughout this case, Shannon...
So, Paul, what was your train of thought? But I think at this point, that appendix is of really no use to me, is it?
You get to see the underlying evidence, you get to see the...
I'm going to get an administrative record in a few weeks.
I understand that, but...
And that administrative record is in fact going to define what the merits of this case are and aren't.
Well, one of the issues that the treasurer has hurt Shannon is her right to remain clear and hearing. To publicly refute the charges that the treasurer has put out there. The treasurer has published the conclusions of her decision that Shannon O'Brien committed gross misconduct, but she hasn't provided the specifics, and it really handcuffs Shannon from being able to explain publicly how these charges are impounded. She wanted a public hearing.
Well, she actually has all of this now. She has all of this. You filed the appendix.
There's no dispute that we as counsel and petitioner has it.
Right, so when you keep saying Shannon needs this and Shannon, what you're talking about is the public.
Correct.
She wants the public to have
She
this.
wants the public to see the lack of evidence and how the reasons for removal are unsupported. And the treasurer represented to the court previously, when we were fighting over the confines of the hearing, that the ultimate decision by the treasurer identifying the reasons for her decision will be available to the public, as will any subsequent request for judicial review of that decision. The court relied on that. The treasurer made that representation. We understood that to mean that when it's time to file this petition, getting aside the fact that it was foregone what was going to happen, that Shannon was going to be able to publicly declare her name in the court of law through filing this. And then when we do that, we get an emergency motion to impound that doesn't identify what is confidential and personnel. And then we hear this FIPA argument for the first time, and you've seen the citations to counsel from the letter from the treasurer's counsel, Morgan Lewis, who prosecuted the hearing, saying this is all confidential and personal information. FIPA was never mentioned once. It didn't come up at all. And aside from the fact that the treasurer and the CCC have both failed to even comply with the uniform rules of impoundment because they haven't specified what information. They just make these citations to the pages. But like you said, Your Honor, there's Superior Court decisions. There's transcripts in there. How could that possibly be FIPA protected? But when we look at the actual statute of FIPA, it says personal data is information not contained in the public record. And like you said, the public interest is high. Elected officials, publicly appointed officials, public agencies, everything is presumed to be a public record until the agencies make a show. They have not made that show. They've had multiple bites of the apple to make a show, and they fail every time. The CCC just entered the case this week. They don't even identify what is in the appendix that should be confidential and personnel related under the statute. It's highly unfair to Ms. O'Brien that she has to keep fighting over this. She wants the public to see the unfounded charges that took her out of office. At every point, the treasurer has walked back. It's simply unfair. And FIPA just does not apply. There's no reading under the statute or the one case law that Attorney General cites that stands for that proposition.
There is, of course, a procedure under Standing Order 196 for all of these issues to surface. Again, this has come up and we're fitting a square, we're trying to fit a square peg in a round hole because of the backwards way the case got here, with an initial filing of an appendix that looks like an administrative record but is not. And so now we're here with a document that the agency hasn't certified to be the administrative record and hasn't proceeded in accordance with the normal operations of Rule 196. That's the peculiarity.
I agree it's peculiar, but the treasurer doesn't really have a right to tell the petitioner what she can or cannot file as a part of her complaint. It's her document.
Well, there are rules, though. I mean, there is a Rule 8. Someone tells me a 1,700 document appendix doesn't really satisfy that rule.
Well, the petition is 30-some-odd pages, but the
Yeah,
one was
that doesn't mean we ignore the 1,700 pages we've attached.
I understand, but the appendix was filed with the single justice so they could see the supporting facts that are referenced. That's why it was filed. I agree there is some overlap between the appendix and the administrative record, but we don't know what's going to be in the administrative record. And I don't think the treasurer gets to dictate, like I said, what the petitioner gets to file to make her case to the single justice in the public.
As far as what happens to the documents going forward, there is a standard under Standing Order 196 that I expect that you're going to follow. If there are additional documents that independently qualify for redaction, that, for example, someone has mentioned attorney-client privilege. If there are documents that qualify for that privilege and that privilege has not been waived, and again, it's hard for me to imagine what those documents will be that haven't been waived when they were submitted at the, quote, administrative level below. But I'll hear what you say, that there are documents that would otherwise qualify for inclusion in the administrative record, but that nonetheless are subject to redaction because they're attorney-client privilege. Okay, there's a procedure for you to identify that under the standing order and within the time frames that the standing order contemplates. So we have case law and statutes and the like that's in one bucket that I think everyone agrees will not be subject to redaction and the like. If there are bona fide claims of attorney-client privilege that have not been waived, that's in a category that you can identify as part of your filing of the administrative record. Anything that was presented below, again, I'm going to have a hard time seeing how that is not subject to the strong presumption that this is a public case, it concerns a matter of public importance. The strong presumption is that it will be public. And I cannot see any likelihood that provisions of the FIPA are going to supervene the SJC rule that does apply, that does clearly apply to administrative proceedings like this.
Your Honor, I fully understand. Again, it's going to highlight that FIPA creates a very difficult situation for the treasurer, in this instance, as the holder of the personal data, because it provides for enforcement of 214 Section 3B. She can't waive the data subject's FIPA rights. It's up to the data subject themselves. So she's going to have to act to protect the information as in a court order where
You're making an extremely expansive argument as to the application of FIPA. Again, to accept what you're saying, literally every case would be suffused with FIPA-type motions to impound, and it literally has never happened in my 12 years.
well, again, FIPA speaks for itself.
It does. That's why I'm suggesting it can't mean what you say it means. Once a case is in litigation, and it's subject to the procedures of a 30-day review and the filing of an administrative record, the presumption of public availability takes hold.
Right. But
and FIPA does not supervene that.
The stating of 1-96 paragraph 2 does make specific reference to the fact that a redacted form of the decision is under review. So it's the part of the balancing of trying to balance the public's right to know versus other legitimate statutory privacy interests and other interests that have to also be balanced at the same time. This is why this one is particularly tricky. The privacy rights of the individuals who are not parties here are great.
But they aren't. This is not a situation where you have people who are having private relationships exposed, or people who have been victims of sexual assault, or very sensitive family dynamics. You mentioned the 51A context. These are people who work for the government and whose names show up on pieces of paper. And that's what happens when you work for the government. And I've never seen it ever apply to do what you're asking this court to do.
Your Honor, I respectfully disagree. And under Torres versus Attorney General, the discussion of unwarranted invasion of privacy specifically looks at the data subject's privacy interests. Their view of whether information is of a private nature to them. It's part of it. It's part of the calculus that's there. The SJC discusses, leaves unresolved.
And whatever privacy interest someone might have, because their name shows up on a piece of paper, or they made a complaint, or they said, "Gee, I don't like that Shannon O'Brien for reasons A, B, and C." You say that that's a privacy interest. Well, maybe there's some privacy interest there, but of course that has to be balanced against the very compelling public interests in open disclosure. People have the right to know how the agencies of their government work, and if the head of a commission is fired by a publicly elected official, the public has a right to know why. And the FIPA does not supervene that right. Anything further we need to discuss regarding the impoundment motion? So, as to the motion to impound the letter, I'm going to take no action on that until a proper motion is filed that attaches the letter and explains why it should be impounded. I don't have that, and so I can either take no action on it, or I can deny it without prejudice to refiling. It's 6 of them.
Thank you.
Thank you.
That seemed to go very well. Do you expect a ruling shortly?
I don't know. It's either going to be shortly or we're going to get something on February 12th.
Very strong comments about the public interest, though.
Yeah, absolutely.
All right, good.
He was 100% on that.
Good luck.
Thank you.